Tantor Audio, a division of Recorded Books, presents The Chevron Doctrine, Its Rise and Fall, and the Future of the Administrative State, by Thomas W. Merrill. Narrated by Mike Chamberlain. Introduction. James Friedman once observed that the American administrative state has long been afflicted by recurring crises of legitimacy. These crises typically follow upon an expansion of the federal government. Expansions typically mean creating new agencies or conferring new powers on existing agencies. And given that the Constitution says nothing about administrative agencies, other than a few passing references to the heads of departments, it is perhaps not surprising that those opposed to the expansion of federal authority, or just made uneasy by it, respond by raising questions about the legitimacy of the administrative state. The latest crisis of legitimacy appears to have been triggered by efforts of the Obama administration to tackle climate change and immigration reform by expanding existing administrative authority. Agitation about the legitimacy of these efforts led to dark warnings that America is governed by a deep state, and, at least among conservative legal commentators, took as its most prominent target something called the Chevron Doctrine. The doctrine is named for a Supreme Court decision handed down in 1984, Chevron USA Incorporated versus National Resources Defense Council Incorporated. After gradually consolidating its grip for over 35 years, the Chevron Doctrine became a matter of intense controversy at the tail end of the Obama administration. Conservative judges and lawyers, including two of the justices named to the Supreme Court by President Trump, have argued that Chevron must be overruled, or at least significantly modified. Liberal judges and lawyers, including the justices named to the court by Presidents Clinton and Obama, generally think Chevron should remain undisturbed, or perhaps only modestly reformed. Both sides attribute great significance to the outcome of this debate. What exactly is the Chevron Doctrine? It refers to a standard that courts apply in determining whether an administrative agency has correctly interpreted the statute under which it operates. The doctrine says a court is always to proceed in two steps. First, if the court finds Congress provided a clear or unambiguous answer to the meaning of the statute, the court must enforce that understanding. But if the statute does not provide a clear answer, if it is ambiguous or silent, then, as a second step, the court is to enforce the agency's interpretation, as long as it is reasonable. This is the gist of the Chevron Doctrine, at least as commonly formulated. In the scores of decisions that invoke the doctrine, the court has varied some of the terminology, but the basic two-step standard of review remains the same. So, what is the big deal? Terms like clear versus unclear and reasonable versus unreasonable are vague, and conceivably the Chevron two-step does not impose any real barrier to courts accepting or rejecting the agency's view of the law in any particular case. A number of studies have attempted to determine whether the Chevron Doctrine has made any difference in terms of the outcomes of judicial challenges to agency interpretations. The general picture that emerges is that the doctrine has made at most only a modest difference in terms of the win rate of agencies in getting their interpretations accepted by the courts. Agencies seem to have won about 55 to 65% of these challenges before Chevron, and maybe something like 65 to 75% of these challenges after Chevron. This is not a trivial change, but it is difficult to know for sure whether it is attributable to the two-step doctrine. After all, it is possible that courts are more inclined to apply the seemingly deferential two-step standard if they decide to affirm an agency decision, and less inclined to apply it if they decide to reverse. The picture is especially murky in studies that examine the fate of the Chevron Doctrine in the Supreme Court. The Supreme Court authored the Chevron decision in 1984, but it took some time for all justices to accept what this book calls the Chevron Doctrine as an all-purpose metric to apply in reviewing agency interpretations of law. Even in recent years, the Court has found reasons not to apply the doctrine when it seemingly should apply, as when the Roberts Court upheld a controversial interpretation of the Affordable Care Act, Obamacare, and said the issue was too important to decide under the Chevron standard. At the level of the courts of appeals, which sit just below the Supreme Court and hear the vast majority of challenges to administrative decisions, the evidence suggests that the Chevron doctrine is associated with a small increase in deference to interpretations by agencies. To be sure, the overall picture is complex. Different courts of appeals apply the two-step doctrine at different rates, and some agencies fare better under the doctrine than others. And there is always the concern about selection effects, that the Chevron doctrine is used more often to uphold a decision, and less so to set one aside. Even a modest uptick in deference to agencies means that the doctrine is important, although it might not by itself justify an entire book on the subject. The significance of the Chevron doctrine, however, goes beyond its effect on the overall win rate of agencies in court. First, the doctrine may have changed the distribution of wins and losses in ways that are unfair to persons who, for whatever reason, failed to engage the sympathies of judges. As we will see, the legal doctrine that prevailed before the Chevron doctrine, and that persists today in certain contexts, required courts to consider a variety of factors in determining whether a particular agency interpretation is proper. The Chevron doctrine, in contrast, is simplicity itself. Step 1. Is the statute unclear? Step 2. Is the agency interpretation reasonable? For busy judges confronted with complex questions of statutory interpretation, the Chevron doctrine offers a way to resolve the case by saying, if the statute seems unclear, the agency wins. In his last opinion addressing the Chevron doctrine before he retired, Justice Kennedy said he was troubled by what he perceived to be the reflexive deference accorded to agency interpretations by lower courts based on cursory analysis. If this perception was correct, it means some persons may have been treated unfairly by agencies, or at least in ways that are inconsistent with what Congress intended, because they could not persuade a court to take the legal question seriously. Second, and as a mirror image of the first, the Chevron doctrine may have changed the way agencies behave. Donald Elliott, who previously served as General Counsel of the Environmental Protection Agency, has argued that the Chevron doctrine made agencies more aggressive in interpreting their statutory mandate in novel ways. Under the doctrine, he has maintained, agencies began to see less need to go to Congress to secure new statutory authority because they could simply reinterpret existing law to reach the desired result. A recent survey of agency employees seems to confirm Elliott's observation on this score. The Chevron doctrine may also have changed the balance of authority within agencies. Before the doctrine was established, agency lawyers wielded great authority based on their presumed ability to predict how courts would interpret the agency's statute. After the doctrine was established, the power of lawyers receded, and that of scientists and other non-legal experts surged to the fore. Elliott regards this as a good thing, and he may be right. But these are highly significant developments, however one views them. Finally, and perhaps most fundamentally, the Chevron doctrine seems to validate a dramatic shift in power in our system of constitutional government. The two-step standard of review, taken at face value, seems to say that primary authority to interpret ambiguous agency statutes, and virtually every statute is unclear or silent on many points, has been transferred from courts to agencies. Courts, since the days of Chief Justice John Marshall, have been thought to have authority to say what the law is. Chevron seems to take a big chunk of that authority and transfer it to agencies, now widely regarded as part of the executive branch. This is significant because courts in matters of statutory interpretation generally act as faithful agents.
Sample complete. Ready to continue?